Thank you very much. Thank you, Jessica. Nice to see you all. I am Jake Chervinsky. I'm Chief Legal Officer at Variant. We're a venture capital firm investing entirely in the crypto industry. I'm also very honored to be on the board of the Blockchain Association and also on the board of the DeFi Education Fund. And what an awesome event. So really, thank you all for being here. We have 30 minutes to talk about rulemaking and the road ahead. And there is a lot to cover, so let's start with some quick introductions and then we will jump right into it. So maybe starting with Amanda to my right, let's just go with your name, where you work, and what you're focused on day to day.
Sure, hi everyone. I'm Amanda Tuminelli. I'm the Executive Director and Chief Legal Officer at the DeFi Education Fund. We are a nonpartisan nonprofit. We advocate for sound DeFi policy wherever we can. That means showing up for software developers and DeFi users in court and Congress, and very relevant to this panel, at the agencies in rulemaking.
Hi everyone, Jason Gottlieb from Morrison Cohen. I run our digital assets department, where I am honored to be able to work with a lot of you in this room. I also chair our white collar and regulatory enforcement group, and I'm honored to no longer be working with many of you in this room.
Hi, and I'm Judd Littleton. I am the co-head of the Supreme Court and Appellate Practice at Sullivan and Cromwell. My practice involves a lot of APA litigation against the government, which I had a lot of experience with this crowd as of last year, but that has pleasantly died down a bit, as we'll be talking about. So.
Awesome. Well, to that point, I've had the pleasure of speaking to many of you on panels like this before, and as of 1 year ago, and 2 and 3, we would have been talking about exactly what Judd just said, litigation against the Biden administration and the agencies that were trying to destroy the industry in the guise of regulation and rulemaking. But thankfully, that is not what we have to talk about, at least to start today. We get to talk about the industry's efforts to focus on constructive rulemaking. So Judd, maybe let's start with you. Can you walk us through that transition that the industry has made from being essentially in attack mode to now working collaboratively with the agencies on rulemaking?
Yeah, of course. I mean, it is, it feels like we've done a 300 or I guess a 180-degree turn, right? Like a year or two ago, last year, I was sitting here talking about the litigation that we did to invalidate the dealer rule, where the SEC, tried to swipe you folks under kind of like nonsensical dealer registration rules, and we successfully beated that down. And then just not too long ago, also similarly with the IRS broker rule, it's a similar thing where the industry had to litigate against some unreasonable government regulations, but we got a CRA, which is kind of amazing. That's unheard of. But going to the clips, I didn't know that the clips of the Miracle on Ice were about to happen, but I'm a litigator, I like to fight, I like sports, and there's a reason why you always hear coaches talking like in the post-game and pre-game speeches about like, no one believes in us, like we're gonna be fighting and we're gonna win. In a way, it's a lot easier to fight than it is to kind of like be in the driver's seat and have some control. And I think that that's a little bit of the transition that you folks are experiencing right now. When we can just shoot at everything that Gary Gensler is coming up with, that's a pretty easy target, and it's a lot of fun for a guy like me who likes to go in and argue and just sue the government about a bunch of stuff. But now, when you're dealing with, having an administration that listens to you and that is willing to grant regulatory relief, you have to think a bit more programmatically, and that's thinking about not only how do I get the agency to do things that I like, but what kinds of things, what kinds of regulatory actions are going to be the most beneficial for us. And so that can run the gamut from formal rulemaking, which is of course the most permanent and the most kind of stable form of regulatory relief, but also presents a lot of litigation risk, as we showed when we were on the other side. When they came out with formal rules, we sued for it. I think if formal rules that are friendly to the digital assets industry come out, I think we can expect that there's going to be litigation from the other side and from folks that maybe don't want that kind of innovation. And you can also have sort of narrower forms of regulatory relief that I think people should be thinking about, like exemptive orders. There's been a lot of talk about the innovation exemption. Those are a bit more durable. But they don't present the same kind of programmatic litigation risk from interest groups on the other side, all the way down to no action relief, which is very, focused and tailored, and folks in this room will know a lot more about the ins and outs of that than I do. But in general, no action relief is not binding. It's just the staff, and it tells you that a particular practice, they're not going to take action against you right now. So that there can be a time and a place to get something that's as narrow as that, and I think that those are the sorts of strategic considerations that we all have to be thinking about now that we have an SEC and a CFTC that are going to be more friendly to our priorities.
Awesome, and it's great to have that run through of the opportunities for rulemaking and guidance going forward. It's also a new opportunity for the industry, right? A year ago, the SEC would have said, come in and register, and we would have said, no thanks, we're not coming in for anything, let alone registration. But now we do get this opportunity to go in and talk collaboratively with agency staff. And Jason, I'd love for you to tell us a little bit more about what that experience is actually like for those of us who have spent our time in crypto avoiding the agencies. What is it like to walk in the front door and have these conversations and pursue this type of relief?
It's obviously a very different feel. I spent 8 years when I would go to the SEC. They would throw me in the windowless conference rooms on the second floor with the really beat chairs, and they would yell at me and my client for kind of eight straight hours, and it was a fun experience. And now, we go up to the 10th floor in the cushy chairs, and we talk to commissioners, and they actually listen to what we're saying. It's quite a difference. What we found, though, is you really need to tailor the approaches you're making, not just for the particular regulator, the SEC, the CFTC, anyone in Treasury or OCC, et cetera, but you really have to navigate the different divisions within. So you can get one set of answers from the crypto task force, and they say, okay, now you have to go clear it through trading and markets, you have to clear it through Corp Fin. And we've had a number of conversations where they say, well, the rules don't really allow you to do that. I say, yes, I know, you and I, we had this conversation in 2016, and now we're here again. The good thing, though, is they really are trying to figure out ways to be constructive and to move ahead. So it's just going to take a lot more pushing to figure out how we can do that, how we can make them feel comfortable, particularly in the light of attacks we're getting from people who like the status quo.
Great, and let's transition now to talk a little more about the substance of what kind of rulemaking or guidance or other relief we can expect. Obviously, the devil is always in the details. Rulemaking is great in concept, but not necessarily in execution. So Amanda, could you maybe start with the SEC, our favorite agency, to talk about what do you think we should expect from the SEC, and tell us a little bit about the initiatives that you at DEF have been working on.
Sure. So along with many people in the industry, DeFi Education Fund has made a number of submissions to the SEC Crypto Task Force. They have been very welcoming of proposals. So we made two major proposals. One was a token safe harbor, and the other was one that we were happy to work with A16Z on, which is a broker safe harbor. So the token safe harbor basically says that if you are a project intending to decentralize and you're doing a token, you could enter this safe harbor where you would not have to comply with all of the rigors of the full suite of securities laws while you're in the safe harbor and you're doing disclosures and talking to the SEC, so long as you're on this route to decentralization. And as I said, we worked with A16Z on a broker safe harbor, which also would frame people in the industry who are not actually acting as brokers, right? Maybe you're running a front end, maybe you have an app that is not doing all the things that a broker does, like not routing orders on behalf of customers, not collecting transaction-based compensation, among other things, doing all sorts of things, but basically you do not have to comply with the broker obligations under the securities laws, so long as you're doing disclosures and working with the SEC. So I know a number of people in this room have also made submissions, and I think we're going to see inspiration from industry submissions from the SEC. So if I had to make two predictions, I would say we're going to see something on tokenized securities very soon. I think many people in the industry have asked for guidance on how to issue tokenized securities and also how to allow them to trade in on-chain finance. And then I also do think we'll see some kind of token safe harbor, which will give guidance to people about how you can release a token compliantly or release a token that is not a security at all. So those are my two predictions. We'll see if I'm right.
Awesome. And let's transition maybe from the securities world to the derivatives world and talk a little bit about the CFTC. Now, granted, the CFTC is a little bit behind the SEC as we're waiting for hopefully soon to be Chair Selig to take his seat and for the agency to get in the game a little bit more than, of course, they already have been with acting Chair Pham. And Judd, maybe let's turn it over to you. Can you walk us through some of the challenges that Chair Selig will face, some of the rulemaking opportunities, and what you think will happen over at the CFTC?
Yeah, and I think I will start off by saying that I am not the foremost expert in the CFTC's regulatory authority, and I hope some of you know my partners, Jamie McDonald and Colin Lloyd, who are outstanding, and they know this back and forward. But I think, I think looking forward now that Chair Selig will hopefully be in place, the CFTC can actually catch up a little bit to the SEC. And I think the three areas that we see them kind of prioritizing first, this won't come as a surprise because they've talked about these areas in a lot of the joint statements with Chair Atkins from the SEC. But first, event contracts. I mean, as a litigator, I've been following these event contract litigations going on across the country. I find them very interesting. I learned that the CFTC has actually been regulating event contracts since like 1992. There was an Iowa presidential, prediction market that they regulated, which I found very interesting. But I think given all the litigation now, that is particularly the litigation being brought by states, where states are trying to assert authority over these event contracts and the prediction markets, I think that's going to be putting a lot of pressure on the CFTC to take some action, right? Like right now, they are in a position where they need to assert more regulatory authority over it, or else the courts are going to tell them, this is the limit of your authority and this is where the states can come in and regulate under their gambling laws. So I think that's one area that's going to be very interesting to see how that litigation plays out. But if Chair Selig gets into place and can do something fairly quickly, it could actually alter the course of that litigation by determining some of those court rulings. So that's a little bit of a race. The other one is perps, perpetual contracts. Jake said you all have already had a panel about perps, but everyone wants to talk about perps. It'll be interesting to see if there is some guidance put out by the CFTC and the SEC about geo-blocking and about how to effectively do geo-blocking, what kind of geo-blocking is sufficient in the meantime. But I think that the expectation is that the CFTC and the SEC are going to work together, maybe more collaboratively moving forward in this area, as opposed to kind of the traditional turf war, to try and kind of put some metes or bounds around what kind of regulatory authority they can exercise over perps and allow those to be brought on shore and actually start happening in the United States. And then the last one that I'll just mention is just some market structure changes like 24/7 trading. That seems to be one that's on the top of the list of people you saw Acting Chair Pham put out a request for comments on how that can be done in a way that's still reliable and ensures compliance, authority, and everything like that. I think that's going to be the next priority as well.
I agree. I think that those are all great priorities. Same thing as Amanda described with the SEC. The interesting thing, of course, is in both instances, those agencies basically get to choose their own priorities. There's one other instance in which Congress has actually mandated rulemaking, and that is for stablecoins under the Genius Act. So Jason, maybe you can tell us a little bit more about Genius Act implementation and what we should watch for in rulemaking from the OCC and from the Treasury Department.
Thanks. I'm going to read notes off my phone. I'm not checking my text, I promise. So it gets very technical. So we've seen the Genius Act is passed. It's going to be law the earlier of 120 days after final regulations come out, or sometime in January 2027, forget the exact date, but it's mandated. So presumably we're going to have regulations, and Treasury has recently put out a request for comment. So a number of folks have put in comment letters on the rulemaking, which is sort of the first step in this rulemaking process. You can see from the letters there's going to be several battles that are shaping up for rulemaking here, because Genius, as legislation goes, is a little bit skimpy or sparse. It's 30 pages, not the 300 or 3,000 that some of these mammoth bills are. So there's a lot that may need to be filled in. So here's a few areas of battle that are coming up. First, the yield battles from Section 4A11. And there's a few different ones that are buried into this section. First is what happens when third parties who are not the issuer of the stablecoin are offering some sort of yield or rewards. And this is something, and shout out to Zai, I know you're in here somewhere, this is something that Zai has pointed out, where banks and credit card companies are doing this now already. Basically, they're just paying for marketing, and we see a variant of this happening in, I didn't mean it. And we see a variant of this in the stablecoin space. Also in that section, it says that you can't pay yield in connection with holding, use, or retention. What happens if you're doing something with a stablecoin that is not one of those? And I leave it to the linguists to parse out whether there's something that could be not in connection with holding or use. But also that section says not solely in connection with holding, use, or retention. So what happens if you're doing many things? So the Treasury letters are really getting to all of these issues, but there are more. What do you do with a non-permitted payment stablecoin like a synthetic token? Does that count? If it's not a permitted payment stablecoin under the Genius Act, then what is it? Is it security? Is it something else? And what happens when someone who is not a defined digital asset service provider issues a stablecoin, such as blockchain protocols, immutable and self-custodial software interfaces, or liquidity providers, because they are carved out of the act? Now, the Blockchain Association put in a great letter from Ashok, and I was happy to be able to help a little bit with that, where we looked at all of these issues and said, the plain text of the statute's the plain text of the statute. That's it. Don't try to make up rules and try to say everyone's got to do this, that, or the other if the statute doesn't support it. And I think in this post-Loper Bright world, we'll let Judd litigate this. Litigate this out in 6 years or so, but they're going to have to stick to the text of the statute. These battles are just beginning. We're going to see iterations of the battles when the proposed rule comes out, when a final rule comes out, and then again when it's your turn in October term 2032. So there's a lot of questions for OCC and Treasury to resolve.
Definitely. And as you said, the battle is just beginning. And that brings us maybe to the last topic to discuss, which brings us full circle back to litigation, where we all have to live, not just because the four of us are either current or former litigators, but also because it is unfortunately a fact of life. Before we get into that, I'm going to take moderator's privilege to talk a little bit about the road ahead to set up my friends here to talk about litigation. Obviously, a lot of the discussion right now in crypto policy is about market structure legislation, which is extraordinarily important, and of course we all want to get done. However, we may be confronted with a situation where the best we can do is a bad bill. That is to say, a bill that does not adequately protect the principles that brought us into this industry in the first place, the ideals of decentralized finance that we care about so much. And I will say, speaking personally, I would rather have no bill than a bad bill like that. What that would mean is we are relying on the agencies over the course of the next 3 years to craft the market structure to the best of their ability to enable crypto to thrive in the United States. The problem, of course, is that another administration could return to the same views of Gary Gensler and President Biden and try to undo all of those rules. In that world, the most important thing, in my opinion, that we can do is have this rulemaking done as fast as possible, so the rules can go into effect as fast as possible, so that everyone in this room, our companies, can launch products that are regulated under that market as soon as possible. It will be much harder for another administration to unwind a market that is operating efficiently and effectively rather than just words that are on a page. So this leads me, with thanks to you all for listening to me go on, to the question about litigation in terms of the road ahead. And we'll start with Amanda. The question is, let's imagine we do get all of these great rules done in the agencies, and the key is keeping them alive long enough to have a robust market arise under them. Are we going back to court, and what does that look like in a world where we are actually fans of what the agencies have done, as opposed to every other time we've discussed this on stage in the past?
Yes, so unfortunately I do think we're going back to court whether we want to or not. So as Jake alluded to, in the past when rules came out that we didn't like, we prepared to sue. I think the other side of this now is if rules come out that we like, or if innovation exemptions are granted to people in the industry, that maybe traditional finance doesn't like, traditional finance will line up to sue. And I'm not just speculating. I think the letter that we saw from Citadel last week makes it abundantly clear that Citadel is getting ready to sue. If you haven't had a chance to read that letter, you really should. There's a chart in it that describes a whole host of intermediaries, such as self-custody wallet providers and L2 software developers and block builders and searchers and validators. And Citadel describes all of these parts of the tech stack as intermediaries that are meeting the definition of exchange or broker under the securities laws. They are clearly staking out a very aggressive position so that the administrative record at the SEC reflects this position. So when they bring a lawsuit after the SEC puts out a rule that maybe grants relief to certain people, that they'll be set up to do that. So it would be odd for us to write amicus briefs on behalf of the SEC, but it could be that could be the direction that we are going in. We'll see.
Thanks. And Jason, same question for you.
I think to Jake's point, the best way to gain advantage in these upcoming litigation battles, and I'll talk about it at the district court level where I live more of my life, and you know, if you want to talk about appellate courts, that's all of your life. I think we have to create a factual record. So as Jake said, we need to build, and we need to build now, and we need to show actually how this is happening so that in the future, when there's litigation challenging a self-custody wallet or a DeFi protocol as acting as some sort of broker or exchange, we can point to the actual thing that's working and say, no, it's not. Look, this is how it's working. As you can see, at no point is somebody taking custody. At no point is somebody taking control. We have to create the facts that are going to help us in these litigations. So hopefully we'll be able to tell our friends in the federal judiciary, who are all very young, tech savvy, and understand all of this technology very readily, we'll be able to explain to them how all of this works to show that the other side is all wet.
Awesome. And Judd?
And picking up on something that both of you talked about, and this is a little bit tactical, but yet another reason why it is important for these rules to get in place quickly and take action quickly is because, as we are experiencing right now, when you have a new administration as the defendant on the side of a rule adopted by the prior administration, guess what? The new administration often does not want to defend that rule anymore. And that's a great thing for us now, but if the administration switches over next time around and you are now relying on, you know, a different administration, I won't say who, that you don't like, then maybe you're in a different situation where the government is not even defending the action that this administration took. That's not ideal. In that situation, you're going to want to be doing intervening in litigation to try and become the defendant in the litigation rather than just being an amicus in support of the SEC. It's a lot better to be supporting the government than to like come in for a rule that the government is trying to abandon. So if litigation is going to happen, you want it to happen while the current friendly administration is in place and is going to send their lawyers into court rather than the next administration. The other point, and goes to what Jake said, is while it is easier and very practical to push for regulatory relief, I don't think you should give up on the legislation, and I'm not saying anyone will. But you know, when we were sitting here last year, I was saying a lot of times that, you know, the way that courts read statutes now, and with Loper-Bright, it's not appropriate. Courts are not going to find it appropriate to take statutes that are adopted, you know, decades and decades ago and adapt them and say like, oh yes, this fits very neatly into the new world of digital assets and crypto, right? And those arguments were in our favor when we were challenging rules that were regulating and harsh on crypto. They can be used the other direction when, you know, agencies are using old statutory authorities to issue, you know, more favorable regulations. And so really the sort of the goal should be to continue to try and get the best possible legislation, if possible, so that you can shore up any regulations against Loper-Bright based challenges.
Well said. I couldn't possibly agree more. There is no higher priority for all of us than getting as durable policy as possible, and obviously that means getting what we need into the United States Code, not just into the Code of Federal Regulations. But I see that we're running out of time, so we'll close it here with just one last note, which is to say, I think that 1 year from now, we will have hopefully some of these important rules on the books, and hopefully not too many cases back in the courts, and also we'll still be very lucky to have the Blockchain Association fighting for all of these different priorities. So with that, thank you very much, and thanks to my fellow panelists.
Thanks, everyone.